Part 3: Cartel Agreements and Abuse of Market Dominance. The trend of delegation of enforcement to local antitrust agencies continued from 2019. Throughout 2021, it was said that a total of more than 150 cases were initiated regarding monopolistic behaviors, and the enforcement authorities continuously focused on sectors having an impact on the livelihood of the general public, like platform economy, pharmaceutical, commercial insurance, petrochemical, used cars. Among them, SAMR, or the National Anti-Monopoly Bureau, afterwards published 26 administrative penalty decisions, 15 cartel agreements, and 11 abuse of market dominance. Among the 15 cartel agreements decisions being published by the central authority, 13 of them were horizontal monopoly agreement and 2 were vertical monopoly agreement. In terms of specific behaviors, there were primarily concerning price fixing, market segmentation, limitation on production quantity, RPM. In terms of the proportion of fines, 1% to 3% of annual sales were imposed in most cases. Only a few were imposed about 4% to 8%, since the monopoly agreement were reached and implemented for many times, or the competition concerns were relatively high. The 2 RPM cases were about Ball Group Co. Limited and the Yangtze River Pharmaceutical Group. I would like to share with you the case with Ball Group in details. On September 27, 2021, Zhejiang Provincial Administration for Market Regulation publicized a decision of administrative penalty against Ball Group, a leading enterprise in civil electrical industry, on its website. Ball Group was funded RMB 290 million, approximately $46 million US, equivalent to 3% of the company's total sales, for engaging in resale prices maintenance in violation of China's anti-monopoly law. According to the penalty decision, Ball Group implemented RPM practices through various ways, mainly include Item A, entering into distribution agreement with the terms requiring distributors to abide the systems regarding market management, and the markup percentage filled in or required by the company. Item B, publishing price policy whereby requiring distributors adjust the product price according to the company's policy. Item C, requiring distributors to sign a commitment letter to promise to comply with the price policy. The antitrust authority found that the behaviors of restricting or fixing resale prices were actually implemented both online and offline, and reinforced various monitoring and punishing mechanisms. The antitrust authority also analyzed the competitive effects of Ball Group's RPM practices from the perspectives of the advantageous market position of the relevant products and the distributors' reliance on the key products, and found that the RPM practices eliminated and restricted the competition at the distribution stage and the retail stage of the relevant products. To demonstrate the advantageous market position of the relevant products, the antitrust authority cited several products' market share on Tmall, one of the most popular e-commerce platforms owned by Alibaba. The antitrust enforcement against the Ball Group reflects the authorities' prioritization of RPM enforcement in the industry that is closely linked with citizens' life, and once again manifest the authorities' tendency of adopting a harsher approach when determining whether an RPM practice actually eliminates or restricts competition or might otherwise be permissible for its pro-competitive effects. Under the anti-monopoly law, any arrangements between a business operator and its trading counterparty to fix the resale price or minimum resale price to third parties shall be deemed as monopoly agreement, which eliminates or restricts competition. It is worth noting that Chinese courts and enforcement authorities have taken different approaches when determining the competitive effects of an RPM behavior. The courts incline to apply the rule of reasoning through a case-by-case balancing of anti-competitive harms against the pro-competitive benefits, while the enforcement authorities prefer to adopt the approach of prohibition in principle with exceptions for exemptions, under which the authorities will presume that an RPM behavior will lead to anti-competitive effects, but preserve the possibility of justifying RPM in certain circumstances. As a result, in judicial practice, plaintiffs should, in most cases, demonstrate that the defendant has a certain degree of market power so that the restrictions on intra-brand competition would have adverse effects on the whole market. However, in the administrative enforcement, RPM may be presumed to violate AML, even if the party involved only possesses very limited market share, and the party should bear the burden of establishing any asserted exemption from prohibition. Though some guidelines in certain areas, such as automotive industry and the intellectual property area, have exploited the specific situations under which a monopoly agreement could be exempted, there is still no universally applicable rule of safe harbor based on market share for RPM. It is expected that the amendments to the anti-monopoly law could shed some light on how to determine the competitive effects of RPM behaviors or specific exemption conditions, such as certain safe harbor rules. But before that, both business giants and enterprises with limited scale face the same antitrust risk in terms of RPM. Among the 11 abuse of market dominance cases, the specific abusive behaviors include imposition of unreasonable transaction conditions, restriction on trade, unfairly high price, and refusal to trade. In terms of specific industrial sectors, platform economy, public utilities, for example, petrochemical and gas. In terms of the proportion of fines, there were ranged from 1% to 6% of annual sales were imposed. It is worth noting that SAMR imposed a fine of RMB 18.2 billion on Alibaba and RMB 3.4 billion on Meituan, two leading internet giants in China, for the abusive conduct called the either-or requirement. We would like to share with you the case with Alibaba in details. In early 2021, SAMR hit Alibaba Group, the world's largest e-commerce corporation, with a fine of 18.2 billion yuan, approximately 2.8 billion US dollar, the highest antitrust penalty on record in China. Moreover, Alibaba has been obligated to file self-regulation reports to SAMR for 3 years, according to the administrative instructions, which is issued together with the penalty decision. 2 days later, SAMR published another penalty decision made by its Shanghai counterpart against Sherepass, a local online food delivery platform focusing on foreign customers, for its abusive conduct of imposing either-or requirements on merchants on the platform. The local market regulator announced a fine of 1.16 million yuan, accounting for 3% of its sales revenue in the year of 2018. Compared with Alibaba, SharePass is quite smaller platform. This enforcement case sends a clear message that antitrust enforcement in China does not only target tech giants. 3 days after the Alibaba case, SAMR together with other 2 departments held an administrative guidance meeting for Internet platform enterprises, which attached a high importance to antitrust compliance, or more precisely, fair competition compliance of platforms. The meeting pointed out the typical issues arising during the rapid developmental period of platform economy. For example, either-or requirements, killer acquisitions, personalized pricing, and subsidy war in the emerging market, and emphasize that such behaviors that could cause great harm to the competition of the market and the welfare of customers should be taken seriously by the government. As a supervision measure, the authority required the major platform operators to conduct a comprehensive self-examination to rectify any non-compliance issues within 1 month and to make a public compliance commitment. It seems that either-or requirement in China is deemed as illegal per se behavior, at least for platform enterprises. No matter whether the platform possesses market dominance or not, normally enterprises should only ensure the behaviors not to cross the bottom line drawn by the laws, while currently they are facing a higher compliance requirement. That is to say that their aggressive competition strategies commonly applied in the industry may not be tolerated by the government anymore. According to the meeting, the high-level compliance requirements could be summarized as 5 not-to-dos and 5 to-dos, including without limitation not to abuse platform rules and to protect all stakeholders' legal rights and interests, not to foreclose the system and to ensure ecological openness and sharing. The enforcement and administrative guidance represent a mature policy shift. Platform operators in China should take the opportunity to assess their conduct, putting in place robust compliance programs.